Ladies and gentlemen, welcome to our panel on Electronic Privacy Revisited. It is a pleasure to welcome you here today to a continuing series of conversations about electronic privacy here at the American Constitution Center. But as we know, it is hard to think of a better time to discuss this fascinating topic. Every day in the newspaper and on the web brings new fodder for our discussion. We have at the moment a flap, which maybe shouldn't be a flap. Our panelists will discuss this, about Facebook's adaptation of facial recognition technology. Is that not a violation of privacy? We have a fascinating decision by the US Court of Appeals for the DC Circuit that says that ubiquitous surveillance violates the Fourth Amendment. When the cops put a GPS device on the bottom of a car and track a suspect's movements 24/7, said Judge Douglas Ginsburg, that violates our expectation of privacy in the totality of our movements and therefore should require a warrant. Other courts have disagreed, saying we have no expectation of privacy in public. Since our neighbors could track us 24/7 if they chose, the cops should be able to do it virtually as well. This may go up to the Supreme Court next year, and it just shows what a ferment the law is in. There are important debates going on right now in the Federal Trade Commission about do not track. Should e-commerce companies be able to track our movements online and send us targeted ads, not only on the internet, but also on our mobile phones and increasingly in real space? When you walk up to Walmart, should you be greeted by a personalized billboard advertising the cold medication that you bought online last week? And in the Senate, Senator Leahy has proposed important changes to the Electronic Privacy Information Act, and the Commerce Department is also issuing important reports too. So we've got a lot to talk about. To do so, we have a dream team, of course, because this is the ACS. You have their bios. I'll just whet your appetite by reminding you who they are and how great this conversation is going to be. We have my old friend Paul Alm from the University of Colorado Law School. We have Mark Rotenberg, the director of the Electronic Privacy Information Center. We have Randall Milch, the executive vice president and general counsel of the Verizon Corporation. Solveig Singleton, a senior policy analyst at the Competitive Enterprise Institute, and Tim Sparapani, the director of public policy at Facebook. So the way this conversation is supposed to proceed is like a raucous and friendly dinner party among old friends. Some of the old friends just happen to be professionally at each other's throats, so they're going to have to try to restrain themselves when they disagree. But we're not going to have opening statements. We're just going to have at it and try to sort out these fascinating issues for you. So I thought I'd just begin with the obvious question, because it's right in the headlines, and I'm going to ask Tim from Facebook. Tim, Facebook is being...
Thank you very little.
Not at all. You know you're a sport to come every year, and we've got to keep the heat on as part of the fun. So the question is, facial recognition technology, is it a violation of privacy to be able to, without opting in, sort of just sign on and have Facebook look at a picture of someone outside a bar, plug their face into the face recognition database, discover that it's me, and then post my name on the web, Jeff was at a bar last night? Is that a violation of privacy, or is this much ado about nothing?
So before we begin, can I just say, first of all, thank you for the invitation. It's good to see so many friends. It's good to be back. I think this is my fourth time at ACS. I come the rest of the years to listen to other wise people and hopefully learn from them. So it's good to be back, and I see a lot of friends in the audience. Second point, I'm here in my own personal capacity. So you're hearing from Tim Sparapani, not Facebook. So anyone who feels the need to tweet or post a status update or whatever it is you might do, please address any comments directly from me rather than my company. That allows me to speak freely, and I think a little bit more carefully in some respects and more succinctly. This is not a privacy violation. And here's the thing. My company, other companies are we're going to make mistakes. We do. And we will do things which at some point will cross lines, normative boundaries, legal boundaries, I hope not. But this one ain't it. Just to go through a little bit of the history of this program. We rolled this program out in December. But before rolling it out, we did something that no other company does and that I'm very proud of. We had a public notice and comment period with respect to changing our privacy policy. This is something that no other company does. It's akin to the Administrative Procedures Act policy that federal agencies use. We literally put out a comment period on our own privacy policy. We say, here's where we're at. Here's what we'd like to change. Here's a red line version so you can see exactly which commas, semicolons, et cetera, we are proposing to change. And every time we do that, we get extraordinary press attention. I'm sure that you know this. There were a large round of press comments at the time period that happened. Then several weeks later, we announced again with much fanfare and with much briefing of press around the world that we were going to roll out this product, which again suggests to people that they could automate a function which they have been heretofore doing manually. So that again drew international attention. There were articles everywhere. I can tell you that because I spent lots of time talking to press and lots of time responding to press. We rolled the product out. I think that's what we would consider notice in any way, shape, or form. It's certainly far more than almost any company I know and am familiar with has ever done with respect to a product. So what's the product that we're talking about? Although it's been breathlessly reported as facial recognition, something that, quite frankly, you should be concerned about in certain applications, especially when the government has access to such a database. This program, quite simply, suggests to you that rather than manually tagging every single photo of that Christmas party and seeing the same people again and again and again, you could automate the function. That's it. You don't have to use it. You can ignore it. You can pretend like it was never there, or you can avail yourself of the fact that it was automated. And to me, this is neither an opt-in nor an opt-out, and to talk about it in that way, I think, is to miss the point. Last point I'll make, and then I'll shut up at least for a little bit. It seems to me that we do ourselves a disservice when we talk about products in this opt-in, opt-out context, as if that was some sort of talismanic way of protecting people's privacy. If it's an opt-in, then everyone has chosen to be involved in a product, and therefore we should all feel better about privacy. As a consumer, I don't believe that. Because each of you know, and each of you have done this, you have clicked on something on the web that looked so darn enticing you couldn't help yourself. And so you have opted into a product or a service and then gotten something that you didn't expect to get on the back end. And that's what a sneaky opt-in looks like. There's also easy opt-out, and I think Facebook in the main has decided to go with the easy opt-out route. So I think this opt-in, opt-out dichotomy is really doesn't serve consumers as the kind of privacy protection that a lot of people talk about it as. So I'll stop then.
That's great. Thanks so much for that. Mark, you've just filed a complaint with the Federal Trade Commission accusing Facebook of deceptive trade practices for its facial recognition.
Thank you very little.
So I gather you might have a few small points of disagreement. Tell us not only why you think that this might be a deceptive trade practice, but also more broadly what the harm is and why we should be concerned about this.
I'm happy to, Jeff, and I just wanted to first of all begin by thanking ACS for holding a panel on this topic. I think it's a great topic. And I also want to ask the question, you must be a lot of fun at family reunions, bringing people together as you do.
Yes, what do you really think of your brother? That's
Just by way of background, I think the people here will appreciate this. You know, one of the very exciting fields about this area of practice of privacy and technology law is that you do have to be creative, particularly if you're trying to work on the public interest side, trying to represent the interests of users and consumers as these new technologies and business practices emerge. You frankly don't really have the resources to go into a federal court and bring a lot of claims. You have to think about getting involved in amicus opportunities when there are interesting issues before appellate courts, Freedom of Information Act opportunities. If you're trying to figure out why the DHS needs to put camera systems inside your living room, that sort of stuff. In the area of consumer protection, one of the issues that interested us and one of the strategies that we developed early on was the Federal Trade Commission's Section 5 authority, which is the authority to investigate unfair and deceptive trade practices. The U.S. doesn't have a comprehensive privacy law like Europe, for example, and a lot that happens in the private sector in terms of the collection use of personal data is typically not covered by federal or even state statutes. You can dust off some tort theories, as people do from time to time. But typically what we'll do is look to the FTC Section 5 authority. And we've actually done this for a number of years and quite successfully. Tim, you're special, as is your company, but you're not the only company that we have raised these concerns about over the years, and I think with considerable success. We went to the FTC 10 years ago when Microsoft proposed a unitary sign-on system for the internet called Passport. And we said, well, there's some real problems with that approach to online identification. The FTC agreed with us. We went back to the FTC about ChoicePoint a couple years later, big data broker industry that was collecting information. And this is the funny part of that story. They were helping businesses identify risky people, and the company was simultaneously selling the data they had acquired to a criminal ring engaged in identity theft. So I'm thinking there, could be a problem. And then most recently, and I think quite successfully, we went to the Federal Trade Commission when Google wanted to compete with your company. Here we're on your side. And said, well, we need a good social network service too. We've got a whole bunch of email subscribers to our Gmail product. Maybe we should just turn them all into social network Google users of Buzz and make those confidential email address books that they have publicly available. Well, there's a problem, of course, because most people treat their email address books as being private. And we went to the FTC about this, and we said, listen, this is unfair and deceptive. People signed up for an email service. They didn't sign up for a social network service. If Google wants to offer a social network service, that's perfectly fine, but they should ask the person to sign up for the service. They shouldn't sign them up for it. So I'm providing this as a way of background to explain that when we looked at, and we have actually a pending complaint, I should mention this also, we were not happy when Facebook changed its privacy settings. And oh no, actually I got a whole thing to riff on. So we were not happy, one, with Beacon 2007, change in the terms of service 2008, and the changes in the Facebook privacy settings in 2009, which we thought had the net effect of making more personal information widely available than the users intended. And so actually in 2009, we filed a complaint at the Federal Trade Commission, which is still pending there. I will say in the terms of service matter, Facebook was actually quite good about it. I got a call from their chief privacy officer the night we were about to file, and he said, listen, if we back off this change, will you guys not file your complaint? And I said yes, and they backed off their complaint. We actually had a good discussion afterwards. So there's a lot of history here. Now, Jeff, I'm not answering your question. That's become increasingly obvious. But what I think yes. But what I think I'm going to do is actually encourage people. It's a great topic. I checked this morning, by the way. It's the #1 topic on the net right now if you do a search for privacy, Facebook and face recognition. Take a look at our complaint. It's on the EPIC website. You'll see the facts that we allege. You'll see the legal theories. You'll see a bit of background. And you'll see the relief we're seeking. Maybe we're right, maybe we're wrong. That's why they're, as they say, decision makers. So this one is to the FTC.
Fair enough. So check out the complaint yourself if you want the details. But therefore, I've got to ask Paul to answer the question about the harms that Mark dodged. Paul, you have argued very powerfully over the years that we should not be slaves of technological determinism. We shouldn't assume that merely because a system is architected in a particular way, it has to be that way. And I remember conversations with Google, I think 2 years ago, where they told me that they were not going to implement a facial recognition app. They could have done it 2 years ago, it existed, but they thought the dangers of misuse and the threats of privacy were so great that they just chose not to hardwire this into their web browser. Was that a good decision? Should Facebook have done the same thing? And please, if you can, in answering this, tell us why, if at all, we should be concerned about this and what the right solution is.
No, and I too really do appreciate being here, and thank you to ACS. I guess one of the lessons we've already learned is when Mark Rotenberg says, oh, there I was doing something nice for your company, it's a setup for what's coming around the bend. But we are really, really lucky in this country to have such an active civil society represented by fine companies like, fine organizations like Mark's that watchdog and safeguard internet online privacy. I don't want to spend the entire panel beating up on one company. I'll spend a little bit of the panel beating up on one company, but you know, I will say that there are some really, really important themes here, and you've already teed a couple of them up. One is, I think, and I've been making this argument for several years now, so a lot of these people have heard this already, we've reached this inflection point in computational sophistication, data analytics power, storage capacity, and what we're going to have to reckon with for about 20 years or more is that privacy is implicated not just in the data someone has about you, but in what else they can determine about you based on the data they have. And that's a really different way of looking at the world, right? Traditionally, we've thought of people holding, you know, our health diagnoses or the last couple of movies that we went and watched. But what we're going to learn, and I make a lot of predictions based on a lot of active computer science, is that with each passing year, the risk will come not from the data they have, but what they can do with it. And so I have an article in the UCLA Law Review called Broken Promises of Privacy, where I talk about the fact that if someone takes out all of your personally identifiable information, which is a term of art we've been using for decades in this field, it doesn't matter quite often because they'll still be able to tell that the person who went to this movie and has this type of car and is of this age is probably you, or maybe you and 2 other people in the world. This is going to rapidly change the way we think about regulating privacy when we do, if at all. So let me bring this back to facial recognition. Facial recognition to me is a very good example of exactly this kind of inferential data. A wonderful scholar at Carnegie Mellon, Alessandro Acquisti, if you are in this field, you should know his work if you don't already. Every time he does a study, it changes your worldview of a small part of this. Has a recent study, not yet published, but he's talking about it publicly, so I'll feel free to do the same. A study where on the Carnegie Mellon campus, he stops people walking by, asks them if he can take their photo, and then with that, does facial recognition, probably similar to the type that Facebook is using, and by the way, I think that is the right term to describe this, and was able to determine, and here I'm going to get the statistic wrong a little bit, 45 or 55% of the people, he was able to find their public Facebook profile based only on this kind of grainy photo they took in the quad at Carnegie Mellon. Okay, so if that alone doesn't impress you with the power, he connects it then to his last study. And his last study, which really shook a lot of people up in privacy, demonstrated that the Social Security Administration wasn't quite as rigorous as they could have been in randomizing the assignment of Social Security numbers, such that if he knows the city you were born in and around the time you were born in, he probably can guess your Social Security number within, you know, an error of about 100. And so diligent identity thieves obviously could use this information, ask you a few seemingly benign questions, and find your Social Security number. So what he's done in his last study is, with many of these students walking by on the quad, he took that photo and turned it into their Social Security number without asking them their name, their date of birth, any of that, because that information he could get from Facebook. Okay, this is to me the most salient example of the chilling possibilities of being able to take the data you have and learn new things from it. But I do want to highlight that it's a real puzzle for regulators and policymakers and people, thought leaders like you in the room, to figure out what we do about this. It's a tricky proposition to say you're in trouble under privacy law because of what you could figure out based on that limited amount of information you have. There are some First Amendment ramifications we must reckon with. There are some really legitimate complaints that companies are going to have about living under that kind of regulatory scheme. But if we really care about privacy, if it's not something we're just willing to give up on, I think we're going to have to more often think about regulating companies for the inferences they can draw, not just for the data they hold.
That's a powerful way of putting it. There was that Reporters Committee case a few years ago that said there's no problem with aggregating data because the whole is not more than the sum of its parts, but you're suggesting it actually can be. And Judge Ginsburg said the same thing in his opinion, that when you know the totality of someone's movements, you're learning much more about them than simply snapshots along the way. Solveig, you've written very powerfully about the difference between public sector and private sector regulation. Facebook in the US might be hard to regulate in terms of this app. In Europe, there will be lawsuits on the grounds of the right of oblivion, which is increasingly being introduced. The French have proposed this right. The Americans, of course, all want to be remembered. The French want to be forgotten. It's straight out of Sartre. And this right, if it's up and running in the European Union, could say that if you take a picture of me outside the bar and post a picture of me with my name, that would violate my right to oblivion. It might even violate existing data privacy law that said that unless there's a journalistic exception, you can't identify people in public. In the US, we might not go for that. Solveig, are you more concerned about the use of, say, facial recognition technologies when they're used by the government? If the NSA or the Homeland Security Department decided to identify me in front of the bar and then investigate me as a result? And do you think we should really distinguish between public and private uses of this technology?
I do think that if you're thinking about this as a constitutional problem, you would need to look, obviously, first of all, for state action, and there wouldn't be any in the case of Facebook. In the case of facial recognition technology and the government, there, I think, if one starts thinking about that problem, one would start by analogies and think about something like, well, okay, facial recognition technology in the government, let's compare that to something that a cop on the beat would ordinarily do. You know, would he recognize the people he saw around his neighborhood? What if he were using a dog? You know, what would that dog be able to do? And what's the traditional way we think about the constitutional analysis of that problem? I think the Facebook case, to go back to the private sector, poses a very interesting challenge, because generally the rule has been in the private sector that human beings can make inferences about human beings and form opinions about them. And then that's been an important part of the way that human beings, whether in the commercial sector or in the personal sector, go about their social lives and learn about one another. But now we have coming into this sort of age-old, historic human context, we have a lot of technology which has the potential to change some of the repercussions of that. And so it can certainly be helpful to clarify at this stage of the game, a few years down the road, some of the rights and duties in this area. I think, though, that if you start if you're sort of feeling your way through this at an emotional level, you're very quickly going to get all tangled up and scared. And so the way I would start thinking about this problem is, first of all, what has Facebook done? You know, to my mind, they're simply making a tool available to their users that will have a lot of benefits. So far, the tool in itself doesn't do any harm to anybody. It is possible that somebody could take that tool and use it to do mischief. And for example, you could take somebody who, say, anonymously posted a image of maybe their child playing on YouTube, thinking that their YouTube post is anonymous, and they can show this amusing image to everybody without anybody knowing who the child is. But somebody could potentially say, take a clip from the video, put it in their Facebook page, and then possibly get an identification of who that child is, which, you know, is not at all, but that would not be something that Facebook had done wrong. To analyze what Facebook has done, I think you need to look at the law around what is the proper way in which one can change the terms of a contract once it's already up and running, so that there's a body of law there that's familiar. And so I think it's to contract law rather than to privacy law that would provide the best guidance as to how to think about what Facebook has done. Further down the road, if some users of Facebook start using this in mischievous ways that do more specific harms, then that might call for a separate analysis. But I do think that if we get into the habit of every time a social networking service or a service that interacts a lot with consumers on the internet kind of rolls out something new, if we get into the habit of sort of bringing a lawsuit every time that happens, that's going to be very problematic for innovation.
Randy, when we first started the planning sessions for this panel, Tim had not joined it, and you were worried that it was going to be a beat up on Verizon panel.
I can leave, really. I'd be happy to walk against Randy.
And I promised I would protect both of your interest. But you guys did get beat up, as you know, in a few years ago. It seems like decades in the privacy world for during the Bush years for the surrendering of personal data for national security purposes. I want to ask, what's the next round of mobile privacy violations that you fear? There's this flap now about iPhones and Android giving out locational devices. Increasingly, ads are going to be targeted over the mobile lines to individual devices. There will be privacy controversies. What is it that you fear, and what sort of regulation can protect you against it? Because I know you're concerned about the patchwork regulations that respond to scandals retrospectively. You know, and I'm sure you don't want to be caught in one of these in the future. What are you afraid of? What regulation do you think should be adopted to avoid it?
That's a very interesting question, Jeff, and I want to thank you and thank ACS for putting this on and for inviting me. Let me start with the notion that was raised earlier, that we do not here in the States have a comprehensive privacy law. In some respects, I think the notion that Europe does have a comprehensive privacy law or a consistent privacy law is actually not true, because the privacy directive gets nationalized in every state and is somewhat different. And certainly vis-a-vis the government in those various states. My own experience is I think that people in the United States would be very surprised at the relative ease compared to the United States with which governments in Europe are able to extract information about their citizens. Indeed, in my opinion, we have it's very much the inverse. You know, in the United States, people are very concerned about information going to the government. I understand that. That's sort of our roots. We have a different attitude, as Solveigen pointed out, or we should have, I think, a different attitude about the commercial use of information, because I think we have a different view in the United States generally about commerce than they do in Europe. In Europe, it's very much the opposite, in my opinion. There tends to be less of an issue from a citizen's point of view, or seems to be less of an issue. I really can't tell how it, can't pin it down precisely, about information going to the government, and much greater concerns about commercial uses of information. So I think you start off from a perspective that, in my opinion, that we have this dichotomy here. So if you want to talk about the issues that are going to come up, I think that and how we ought to set out boundaries about what information can go to the government, which is really the ECPA topic, right? I mean, ECPA is really about the provision of information to provision of information to the government. It's not really, save for one aspect, a generalized statute about the use of information, other than going to the government. You know, and you start off down the road of trying to modernize a statute that is old, comparatively old. It's not that old and compared to some statutes, but I think for the internet generation, it's ancient. Anything that came from before 2005 is ancient. You need to try to, in my opinion, simplify and clarify items. Take the bill that Senator Leahy dropped. You know, it centers on there's a whole aspect of geolocation. That's certainly a very popular and big topic at this point. I think that the aspect of this that is critical, of course, is that what we all found out is that the geolocation capabilities that were at issue for Apple and Android were geolocation capabilities that were placed on the devices by their manufacturers and their software manufacturers. They weren't anything to do with the traditional telecom networks one way or the other. The telecom networks are increasingly disintermediated from the information that is calculable or extractable from the devices and goes directly over the internet to whoever put the app on or is able to, you know, put that together. It raises the issue, which I think is important, which is, first of all, if you're going to try to have a statute that deals with the provision of information to the government, you have to think through whether the entities that are subject of ECPA actually encompass all the entities, right? Is an app provider a remote computing service or an electronic communication service provider? It's not clear to me that they are. That information would go over the internet to whoever, wherever it's directed. So you need to, first of all, figure out the ecosystem a little bit differently. You need to look at it in a different way. And then I think the next thing you need to do is once you figure out the ecosystem, try to treat players the same. I think we have, as you mentioned, a disaggregated way of looking at privacy. We have HIPAA for medical records. We have Gramm-Leach-Bliley for financial records. We have ECPA for certain telecommunications records. We look at it in a very disaggregated fashion. One thing about the internet is a lot of these boundaries are disappearing. A lot of the types of boundaries are disappearing. You have multiple potential statutory regimes you have to deal with. So I think we need to figure out whether we're content with these siloed approaches, or we want to have an approach that crosses the boundaries and tries to say, okay, we're basically going to treat this information industry more or less in the same way. We're going to look to see in products and services, what's necessary for the product and service to work, what's beyond necessary for the product or service to work, and is a place for making additional funds. And you can start to build a matrix that contemplates and has levels of protection for the information depending on where it comes from, what it's going to be used for, and where it's going to go. And I think that if you did it that comprehensively, it would be a different thing. I've avoided a little bit your question on what the next big item is. I've learned that predicting the next crisis in the internet is a fool's errand. I think that you'll find that people are probably generally much more concerned now about hacking and cybersecurity, and they should be concerned about hacking and cybersecurity, because I think it's a significant issue that, in some respects, deserves attention that deserves as much or more attention than the whole question of what information goes to the government.
You're right. It's my job, not yours, to predict the next crisis. So that brings me back to Tim, and to suggest that here's one possibility for the next crisis. Maybe not next year, but in 5 years. So the people at Google in 2007 told me they expected that within, I think it was 5 years, they expected to face greater pressure to put on Google all public and private surveillance cameras and make them live. And that's increasingly easy. There are now Facebook apps for live beach cameras in Mexico, for example, which, as you can imagine, are popular with teenage boys. Tim, you will be faced like Google. You're going to be asked pressure from the government or from voyeuristic consumers. Unite all of those apps so that if these were all united and stored, it would be possible to click on a picture of me, back-click on me to see where I left the house this morning, forward-click on me to see where I'm going after the panel, and possibly to have ubiquitous surveillance of everyone 24/7 in the system. If asked to unite the cameras, Tim, would and should Facebook do it? And if not, why not?
Boy, that's a pretty dystopian vision you just put out.
It was Google's vision originally.
Okay. I'm far more optimistic, and I actually think the crisis that the opportunity that you raised at the beginning of the outset is a little bit more interesting. So if you don't mind, I'd like to talk about the Walmart example that you suggested. Should we walk into Walmart and have ready for us as we walk in the front door a customized, personalized, or individualized list of opportunities for us in that store? And I think that's also the great question for the online world as well. Increasingly, I think we will find, as you go to every website across the web, that people are offering you, and I mean you, an individualized experience. If you show up at the Washington Post, you will get news that is probably dedicated, raised, in terms of highest priority for you, news that looks like the news that you clicked on in the past. When you do go to CNN, the same will be true. When you go to a sports store online, they will probably raise the sports that you care most about. I'm a soccer fan. Soccer would show up first. And the Walmart experience that you're talking about, I think, is where we're headed. So to me, the great question is, are we comfortable with the fact that we will have massive efficiency gains, individual benefits, customized services and products, or do we think that de facto those are some sort of privacy violation? And to me, I'm actually more optimistic the benefits will significantly outweigh the burdens, and that if we're looking ahead of this curve, which I think is already happening, we can put in place burden limiters, regulations, laws, if we need to, that prevent the downside of those opportunities. So that's your first example is the one that grips me, and I think it's the one that's closest to happening, and therefore I think it's more fruitful to discuss that. So.
I'm glad you raised it, and we will discuss personalization, but since I asked, I'm just going to ask again. You know, Facebook is going to face these pressures.
Right.
Should it accept the request to unite all the cameras, or should it not, in the interests of privacy, democratic values, and liberty?
More important than the should we is the fact that we can't. So one thing that's really important to remember is that every single app that we call a Facebook app is made by, developed by, run by, and owned by a third party. There are millions of small business people who have created applications on top of the Facebook platform, just as they have created applications on top of the Google platform, the Apple platform, et cetera, Salesforce, Microsoft, et cetera. But these are third-party entities. They have typically, at least with respect to Facebook apps, we have insisted that they have their own privacy policies. And those are there, and we insist that those apps have those privacy policies because those people have direct relationships with their customers. So whether we can or will, whether we should or should not, the real question is, can we? And the answer is absolutely not. So I sort of reject the hypothetical, Professor.
Great. Again, it's not a hypothetical. Google says they will be asked by the government and by private entities to unite the cameras, and you're saying that you can't and won't do it by uniting apps, but it still will be possible technologically, and you will face the same pressure to do it in other ways. So you will face this debate, and I hope that the debate over the facial recognition at least might inform some of the decision about whether or not to unite. But Tim, I'm very glad that you raised this question of personalization, which we should all talk about now. So Mark, Tim says this is great. You sign on to the sports site and you find out about soccer, you go to Walmart and you get your favorite candy or chocolates. There are obviously possible privacy violations. You could walk up to Walmart with your wife and see the pixelated billboard ad for the lingerie you bought last week for your mistress. That would maybe
always a concern.
Always a concern.
Yes.
Best not to go to, but don't buy it at Walmart, just whatever you do. But what I want to know, Mark, is it really privacy we should be most concerned about when we think about this world of personalization? Some have called it follow me advertising, right, so that ads are actually tracking us to our mobile devices and at Walmart. Or is it really a question of economic discrimination? I was struck to learn recently that the New York Times had 3 months of free subscription to its digital service if you clicked on a Lincoln Mercury ad. But not, and this was at a privacy conference, not everyone got the Lincoln Mercury ad. Only the good consumers who were valued for being high spenders got the ad. The rest of us didn't. We felt discriminated against. We didn't get free New York Times. Are we going to see more and more tiering, redlining, social discrimination in this world? Right. What are you most concerned about when it comes to personalization?
Well, let me say it's a great question, Jeff. And also, one of the things that you will learn about privacy in this area is that it quickly runs over into much broader questions. You're raising economic discrimination. I actually think that when we talk about personalization of the new media, we're also talking about the character of political discourse. I mean, this was an issue, for example, that Cass Sunstein wrote about Republic.com. Ellie Pariser from Move On wrote about recently in the filter bubble. And I think, Cass and Ellie and others have said, this ability to personalize is not just about which ads you're seeing. It's the news selection. It's the information you receive. It's your understanding of the physical world as it's projected, filtered, and interpreted through these new interactive devices. And I think, these questions are profound. They go to the issue, for example, of page rankings on Google. Now that has commercial dimensions, because if you're selling a product and your competitor's way up in page rankings, you're thinking to yourself, why did Google do that to me? But if you're looking at the history of Tiananmen Square, for example, through a Google search engine in China, and you see wonderful vacation photos, you think to yourself, hold it, I thought there was some controversy here that's part of our history that I need to know about. So. The first point to make is, as I said, personalization actually points to much deeper issues about how we receive and understand information in this digital world. Personalization, I think, does also raise concerns about privacy, and there is a paradox here. In my view, one of the best antidotes to these privacy invasive techniques is greater transparency. So to the extent that we receive different versions of reality, I think we all have the right to know absolutely and completely what those factors were that contributed to the placement of that news story or that ad. What is it that is known about me by this commercial entity that leads it to post this ad and not another ad? I think I have an absolute right to obtain that information. Now, privacy policies typically do the opposite. They tell you virtually nothing about how the information regarding you is manipulated for commercial purposes. They say in the most broad terms, we provide information to you that will be useful to you. Please don't sue us or tell Mark Rotenberg at Epic what we're doing. I mean, that's kind of a typical, privacy policy. But in reality, a real privacy regime would say, this is the information we have about you, this is how we use the information, and this is how it changes your online experience. And of course, that would also enable you to make some meaningful choices.
Paul, I'm delighted to have the chance to ask you about personalization and anonymity. So here's how I understand the technology at the moment. I'm writing about it now, and it took me a while to figure it out. Maybe someone will correct me, but here's how real-time bidding works on the net. So there's an anonymous profile of me, and it knows that I searched for a Hawaiian vacation from DC. And it packages that together with other of my online buying habits and puts me in a category. Nielsen has categories. The good spenders are people like young digitalati, the high spenders. The bad people are blue-collar blues, the ones who eat a lot of fast food and don't have a lot of money. So basically, then my profile is offered up to auction. A company like Blue Kai or the Google DoubleClick exchange will say, there's this anonymous profile who wants to go to Hawaii and is a young digitalati. Companies will bid on it. Whoever wins the auction can serve me with an ad wherever I show up on the internet on a site that's part of the DoubleClick exchange. So no longer do you have to buy New York Times ads hoping that you're going to hit people like me because I read the New York Times. You're actually auctioning me in real time, but it's supposed to be anonymous. How meaningful is anonymity in this sense?
And I will get to that in a second. I love the opportunity to talk about one other thing with personalization that I've been thinking about a lot, and some of the comments from the end of the table have got me thinking about it even more. I despair for the current generation of computer programmers. Right? You go to this highfalutin computer science program, you're taught the finest algorithms, operating systems, compiler theory. You think you're going to change the world. You graduate and get the plum job at Google or Facebook, and you are told to spend the rest of your career wringing pennies out of people because that's the only way we can sustain the type of growth we've historically enjoyed. It wasn't the same for me when I was graduating from college in 1994, degree in computer science, and my friends and colleagues were going off to Google and to Microsoft, and they really thought they were going to change the world. Whether they did or not, I guess, is open for some historical debate, but at least they really had this opportunity, I think, to do something meaningful. And I'm trying to make the argument that it's a sad state of affairs if the only opportunity we have for market growth is wringing pennies out in this way. And this goes to kind of comments that we've heard and we hear throughout privacy debates about the technological determinism and the kind of free market absolutism that is used to squash any attempt to suggest that we reduce the risk of privacy harm. Right? I mean, you hear that constantly. It's quite a effective and large mallet that's used. It works on the Hill to say this is all about innovation, right? That's a word that's already been used once today. You're going to kill innovation. You're going to kill the American economy. People will be out of work. I don't think so. I think these young computer scientists who are graduating today can find other ways of making money for corporations other than wringing a couple of pennies out of me. Okay, so let's talk about the harm. So what I've described in my article is something I call, and yes, I picked an intentionally dramatic name, the database of ruin. And so the idea here,
even by professorial standards, that's wonderfully alarmist and hyperbolic. Good work.
So the idea here is that, and you can raise your hand if this doesn't apply to you. For almost every person in an advanced democratic society, there is a fact about you squirreled away in an electronic database somewhere that you wouldn't want your worst enemy to be able to obtain. right? It could be something about medical history, family shame, drug use, whatever it is, it's out there somewhere. It may have been put there by you in Facebook. The argument I've made in one of my papers is, in the past, we could be secure in the knowledge that that database was separated from lots of other databases, and that database didn't include your identity. And so you were protected. But what I've tried to argue is, as we allow companies to amass ever larger databases, the digital dossiers that my friend Dan Solov has written so eloquently about, we should begin to imagine that all of these databases in the world are coming together as one giant database of ruin. And so when we talk about things, and I forget which of my co-panelists talked a little bit ago about, this isn't Facebook, causing the harm, it's the bad person who accesses their database and uses it in a way. I disagree. I actually think that companies who are allowed to create ever more sophisticated dossiers and portfolios of you are at least partly culpable in kind of moral and ethical ways to the harms that they are enabling, the risk of privacy harm that they are enabling, even if it's never company policy to harm you themselves. And I would like to see law and policy begin to reflect that more than it has.
So the American response to the dangers of personalization is the FTC's proposed do not track regulations, which might be nothing more dramatic than an opt-out button that is placed on your browser, or it could be something more intrusive. Is that sort of private regulation appropriate, or should we not worry about the harms of this in the private sector and focus on government violations?
I think it would be helpful at this point to clarify some of the rights and duties that attach to information traveling around in the private sector. I do think that it is important to be aware of some of the benefits that could come out of some of the uses of this information, as well as the harms as you go forward with this process, and not to sort of prejudge the case and assume that the harms will tend to outweigh the benefits. There were some interesting studies of advertising that were done back in the 1970s when there was a lot of controversy about the regulation of advertising. And they showed that in markets where advertising was banned, consumers tended to pay higher prices and have lower quality products. And it seems as though, even though an individual item of advertising information that's delivered to you might be biased, obviously, in favor of the producer, the fact that you're being bombarded with messages by competing sources means that, on balance, the net effect is that it's better for you to be bombarded by this biased information than it is for you to have a lack of information. And so that advertising in a competitive context where one sort of crier in the market is saying, buy this, and another one is saying, no, mine is better, buy that, is the overall effect of this kind of thing is that you do get benefits for consumers that are linked to the same kinds of benefits you see for consumers from the competitive process more generally. Now, having said that, I will say that I think that clarification of some of this space at this time would be helpful, but it's important here not to assume that the net effect of this activity would be harmful, or to assume that the net effect of it would be beneficial. I think it's helpful to wait until a specific harm emerges and then address that.
Randy, talk about personalization in the mobile space. This is a very contested and open area. There are companies that are doing digital tracking online that will not go into mobile because they think that the notion of anonymity is meaningless when you're actually targeting those lingerie ads to an identifiable phone. And until the technology is worked out, they think that anonymous tracking is not possible in the mobile space. Just explain to us how the technology is going to work. What are the options for sending mobile ads to mobile phones, and how some of the privacy concerns could be obviated by maintaining anonymity?
Well, so let me make clear that, from our perspective, targeted advertising for Verizon has always been a matter of robust consent by the user. Indeed, we have yet to really embark on targeted advertising in any sense because of our concerns over building products that were fully fully able to be robustly consented to. Sorry for the poor English there. So I think that you're right. In the mobile space in particular, I think that there remain to be some issues. The value of anonymity, however, is in some respects potentially trumped by people consenting to undertake certain activities. I am struck by the sort of only glancing recognition that last time I looked, people join Facebook voluntarily. People undertake many things voluntarily. You only have to be my age and have two post-teenage daughters to understand that at a certain level, folks view privacy very differently. This is a very personalized area. And the things that show up on Facebook on certain pages, certain walls, certain whatever they are. Excuse me, Tim, I don't mean to be a troglodyte when it comes to Facebook, but it scares the bejesus out of me. Is astonishing to me. So I think that other than a plea that their brains are not yet fully formed and they can't really have consent, you do have an awful lot of people doing voluntary things on devices, congressmen even, that leads you to wonder, leads you sometimes to wonder at sanity. But you have to start off, I think, from the notion that people are doing this voluntarily. And they do need to have robust understanding of what they're agreeing to. I agree 100% with Mark that the FTC approach that looks at what your privacy policy is and makes a judgment about whether you have kept to your privacy policy or not is an excellent approach. I think that having a single privacy effort in that regards. I mean, I think that one of the problems we have is the sort of the differential approaches that we have in various agencies in the government. I think it ought to be centralized in a single place, and I think that holding companies that have information and use information to what they tell their customers is the right way to do it.
I don't, by the way, just in case there's a misunderstanding.
Okay, I didn't.
I was only. These are two very different approaches.
I was only referencing the fact that you have utilized. You start off by saying that you utilize the FTC's Section 5 authority.
Right, but the privacy policies do the opposite, because what they are is a form of disclaimer, waiver. They basically tell people this is what's going to happen, and if you go ahead and use the service, you're stuck. And this is not a good approach to privacy protection. So this may be your view, but it's not mine.
That's fine. I mean, that was the essence of the decision in Google, however.
No, it wasn't. It had nothing to do with their privacy policy. It had to do with their representations regarding the offering of an email service, and then their subsequent decision to take that information and use it for another purpose.
And the fact that their privacy policy didn't disclose that they were going to have an additional use.
No.
So if their privacy policy had disclosed that, do you think they would have had the same situation?
We wouldn't have looked to the privacy policy. Again, we would have looked to the representations that were made about the service, which is, by the way, a big part of the theory involving Facebook and facial recognition.
Okay, well, I don't mean to, certainly won't misstate, but you're the expert of your complaint and the result, so I will certainly recede to that, although I do believe that it's important to understand that consent, I believe, is a fundamental aspect to this. And I do agree that there's an aspect of...
I don't agree with that either. I'm sorry. I mean, you know, the big problem that we have today is that so much data is acquired by organizations that individuals don't have any direct control with. The entire internet advertising model is based on acquiring information about individuals beyond their control. So consent in those relationships as well is not a meaningful concern.
But people tend to forget that targeted mailing and targeted advertising is a very old technique. You know, there has not been, in pre-internet days, corporations and other people, nonprofits, people who were trying to raise money for good causes and bad, used targeted mailing. I know people don't remember that anymore, but used to get targeted mailing. And the way that they did targeted mailing was they used all sorts of data that was available to aggregators of data who had complicated algorithms and they probably had to use a Babbage machine back then to figure out how to mash it all together. But it's an old technique. It's not a new technique. Now, I will allow as how the increases in computational speed, the increases in the number of bits of data, and I use that in the non-technical sense, bits of data that are out there and the ability to aggregate them, perhaps the effort is more honed and it is better in a non-normative sense, just more accurate. But the technique is old. And so I don't understand why. I think again, you know, it's, to me, the specter of turning over so I will put it this way. The very same government that ECBA is concerned about giving information to is the same government you would turn to regulate this whole effort. And I know this disturbs you, but it seems to me that if you know, you're not trusting them to do one thing, it's an odd thing to say, well, we trust them to do another.
That's just absurd. I mean, it's the Federal Trade Commission that enforces consumer privacy law, and it's the National Security Agency that comes to your company to get information about your customers. Guess what? Different organizations, different missions. I mean, can we at least get beyond that view that says that because the government engages in warrantless wiretapping, they shouldn't be protecting consumer privacy? Can we at least sort of take that half step forward, or is it all the same to you?
Well, it's
National Security Agency, FTC, you blink, they're like, oh wow, same agency.
It's the same in one respect, and that is you have to take a step to acknowledge the competence of the agency, and I think that there is a fundamental sameness there that is critical. Now, if what you're talking about at the FTC is simply, again, a comparison of representations to the truth, that I think is an allowable item. But what I heard today was far broader than that. I heard questions and suggestions that there has to be a much more overwhelming regulatory state that deals with, okay, what kind of computing power? I mean, I think, Paul, you could solve your problem about the ability to aggregate information if you simply had a rule that no private entity could have computing power over a certain capability, right? If you dumb down computing power, you wouldn't have any problem about being able to make inferences for people. Why not? Why isn't that a good rule?
Now, friends, this is the part in the family dinner party where Uncle Jeff has to bring in the after-dinner drinks and the dessert.
Is that to calm people down?
To calm people down, just a little bit of Cointreau or some
we had to
sticky
do this,
liquor, a little Madeira.
It was far too civil.
Tim's getting a free pass.
Yeah, you see,
no.
it was about being up on Verizon after all.
You ought to see what an Italian family gathering's like if you think this is a problem.
This is nothing. But this was actually a very productive and interesting clash, because what you were debating was a real question. Is this really just translating the old world? It's just like direct mail with slightly better targeting, or is it a difference in kind rather than degree? And now that direct mail can track us into our homes and in every aspect of our lives, is some other metaphor called for? This is the time, ladies and gentlemen, when we have some time for your questions. And I think there's a mic that will follow you, and let me call on this lady right.
Do they have to identify themselves?
Yes, you could identify yourself. No, only if you choose. Opt in. Opt in.
Say where they.
I don't think you have to.
She does have her name on the front of her.
That's fine.
So.
We won't tell.
I've
The
got
cameras can't see.
facial recognition. Could you lift your head up a little bit?
And if you'd like to direct it to a particular person, that's fine, or not.
Well, so my question, a lot of this has been about the consumer world, and I wonder if you could talk a little bit about the government, you know, the big G government, big brother who's out there, and, you know, with doctrines like the third-party sharing doctrine that once you've shared once, you've shared for all purposes, and is that still true, and is that consent? And I think that we have reason to be more worried about the FBI knowing everything about us than we do about Google knowing everything about us, at least, you know, without a warrant. And, you know, should there be more done about the government side of it? What should be done? And, you know, on what side of that, I guess, do the corporate interests line up? Are you for it? Are you against it? Because sharing is sharing. Who cares? So I'm just curious.
That's such a good question, and that question about the third-party doctrine is really central. If you don't mind, I'll ask Paul. The third-party doctrine, which says that if I share information with a bank for one purpose, the bank can be compelled to share that with the government for another purpose. is under great stress. Europe has adopted the opposite rule. They say if you share information for one purpose, it can't be disclosed for another without consent. And I gather there's a Third Circuit decision which is questioning the third-party doctrine when it comes to the digital cloud, because after all, if everything I store on Google Docs or in the cloud I have no expectation of privacy of, then there's no possibility for electronic desk drawers. Should the third-party doctrine be resurrected, and should we be more concerned about this government surveillance?
I mean, absolutely. And really, your question isn't just about public. It's about the line between public and private. I mean, every year, the FBI has a wonderful upgrade in all of its surveillance capabilities without lifting a finger, because if the companies get new pieces of information they didn't used to collect, the FBI can get access to it. And so then it really becomes a question of how difficult is it for them to get that access? What sort of standard do they need to meet? And I think the kind of conventional wisdom of a few law professors is people have made too much of the third-party doctrine. So here you have a rule that arose in a narrow series of cases in the 70s about the telephone numbers you dial and the checks you issue and whether or not your bank has shared access to that information. And people have kind of drawn this line that says, well, of course that means that the entire contents of your inbox is now susceptible to gathering by the FBI without any nod of tip of the hat to the Fourth Amendment whatsoever. I think that's wrong, and I think most people who look at that cases just predict that at some point the courts will step in and say, you know what, this is a very different world we live in today. 40 years have passed. Cloud computing, shared computation, all of the trends suggest that it's a failure of imagination to say that just because the computer architecture has changed, our privacy interests versus the government have changed. So I'm actually not worried about the Fourth Amendment. I think the third-party doctrine will be appropriately narrowed at some point. But then it goes to the separate question, which is, okay, then what hoops must we have the government jump through, right? I mean, you know, assuming that they're able to do something like, required to do something like get a warrant every time, is that enough? I'm not even sure that's enough. I mean, the entire ECPA debate right now has been about warrants and probable cause. And that's all we're fighting about. And I think that's a noble thing to fight about, but I've written an article that suggests that in the internet age, one of the weird things about the way the internet works is if you get an IP address and you know it's related to the crime, you have probable cause almost every time. It's almost never the case that you have an IP address that says, the suspect has a mustache. I've narrowed it down a little bit more. That's not the way the internet works. And so what I'd like to see are other controls put into statutes like ECPA. Judicial review is already baked in, but there's a rule for minimization, for example, in a wiretap case that says, you know what, it turns out if 98% of the email messages you obtain with this warrant are totally unresponsive to your crime, you have to throw those away. You can't keep them and mine them later in the investigation, or God forbid, in another investigation to try and find proof of other crimes. Oren Kerr, who typically takes the side of the government on a lot of these issues, has written rather eloquently a couple of times that maybe we should suspend the plain view rule when it comes to searches and seizures of digital evidence. Maybe we should say, sure, you can kind of have at that person's inbox to look for the crime you're investigating, but when you stumble upon another crime, you actually have to pretend like that didn't happen, that didn't exist. That would be a radical shift, but it might be one that's necessary given the amount of information we all store, where we store it, and the pervasiveness of the surveillance that's embedded in it.
Great, very good question. Yes, sir.
Yes. I am a true troglodyte in this area, and probably the only one in this room who, when he was going to law school, had to dial 611 and ask for the long-distance operator to speak to him.
Wow.
He was 100 miles away.
That's impressive.
There is something that I think I'm not unique in. When I get a terms of service or any other agreement online, I have never yet read it. I know no one who has read it, ever, and I've asked about this, and I want to know what kind of protection can we get to understand the meanings of those agreements that we sign online that say, I don't know, I may be agreeing to pay $1,000 a month for the service. I don't know it because I've never yet done anything other than say, I accept. Whether it's Amazon, whether it's Facebook, whether anything else, that's what I do. And I wonder whether there's any protection we can have to have them disclose in a meaningful way what we're agreeing to.
Great question. I have to ask Tim, because it's been noted that the Facebook privacy policy is longer than the U.S. Constitution. So how can this be avoided? No one has ever read it.
Yeah, interesting point about that is that the New York Times that wrote that piece and made that quip has a privacy policy that's 3 times as long as Facebook's.
Well taken, well taken.
So I agree with you completely. As a user, as a consumer, I couldn't agree with you more. Privacy policies are a disclaimer of liability. They are not a protection for your privacy. This is why I'm proud to say that 3 months ago, Facebook took a really radical step, something we've been criticized by other companies for, by putting out what we call a data usage policy, not a privacy policy. And it is a simple 2-page or 3-page discussion with pictures and diagrams that show exactly what we do with your data and what the relationship is between you, us, and the sharing that we do at your behest. I couldn't agree more that an end user license agreement is nothing like a privacy policy either and does not protect you. I urge people to go look at this. We call it our data usage policy. Internally, it's called Privacy Policy 2.0 because the whole concept had to be rethought.
So I have to ask, are you going to read the 2-page policy? Okay, so I think the point,
Shame.
that makes the most point right there.
Yes, ma'am, right on the end here.
You talked obliquely. I can project. You've talked obliquely about the problem of culture, which seems to be, to me, to be even more intractable in some ways than the problem of what government and companies are doing, because you can at least imagine legal or technological fixes to what the government and the companies do. I'm not optimistic that we'll ever see them, but at least they're imaginable. But there's such a difficult problem with the culture, and that people see the benefits of this transparency about themselves, but they don't see the costs. The costs are invisible, or they require a great deal of technological sophistication. So, people love their e-readers. I don't know how many of them it occurs to that they have no more privacy anymore in their reading habits. And as bookstores decline, you can't even buy a book privately, much less read it privately. That's just one small example. So I'm wondering if you want to address this larger problem of culture, for which, as I say, I don't think there are any legal or technological fixes unless you assume that the culture and law and the technology are so bound together that one will follow the other.
Well, one of the points to make here is I think part of the answer is an understanding that privacy is about a lot more than just secrecy. And if you think of privacy as only secrecy, you'll say, well, information is more widely available, the genie's out of the bottle, and on it goes. Privacy, fully understood in my mind, incorporates many, many important social and legal values. I mentioned transparency. I think there's a due process fairness element about how decisions are made regarding individuals that can also be addressed when information is widespread. And I think we begin to see the evolution of privacy laws that recognize, for example, even when information is known about people, we don't necessarily act upon it or are permitted to act upon it in a legal sense. Now, I know this is going to upset Solveig because it's always a concern, what was the example? Mark is wearing a red tie and somehow we can't say that. But that kind of misses the point. If you look at a law like the Genetic Information Non-Discrimination Act, which limits the ability of employers to use genetic information about their employees in their possession for hiring or promotion purposes. It says, listen, here's data that's available about someone else. It's known, it's not secret, but we can't act upon it because it's discriminatory. And guess what? There's nothing new here. We've treated data about age and about gender and about race in a similar fashion in the past. In fact, in the European construction of privacy law, privacy protection and prevention against discrimination based on personal characteristics basically run together. You're almost describing the same thing. So I guess my answer to you is that the fact that information is widely available doesn't mean the end of privacy. It actually means that I think we need to think about what the control over identity and personal data and how it's used and who has access to it and a full panoply of rights that we're just really beginning to understand at this point in time come into play.
I didn't actually necessarily disagree with anything you said there. I'm not sure what you were talking about. I do think...
just trying to pick fights.
I do think... I thought the discrimination point was interesting because it is interesting that this is also a very potentially subtle and complex area. Sometimes you might think that withholding the uses of certain types of information is a solution to discrimination problems, and there's a role for privacy there. there's also sometimes there can be situations in which additional information can alleviate a problem of discrimination. Discrimination often arises from prejudice, which is based on ignorance. And if you have accurate information about people that is available, that can help alleviate that ignorance and address problems of prejudice. There's an interesting example that comes out of the European Union here, actually. There was somebody from a credit card company in the United States was talking to a European data protection authority and explaining that in the United States, the system of credit reporting makes the information available when somebody does not pay their bills. Now, in some European systems, you can only report positive payments of bills. You can't report negative ones. And so the European Union regulators looked at the American and said, but how would poor people ever get credit? And the credit card person in the United States says, it is a myth that poor people are at high risk for not paying their bills. This is just simply not true. And this is something we've learned from the American system, which lets us process more information. So in the United States, it's actually comparatively easy for poor people to get credit compared to the European Union. In the absence of accurate information about people's behavior, often people will tend to fall back on prejudice. So sometimes it's a more subtle issue than it looks like sometimes at the start.
Yes, sir.
I'm a first-year law student, and as much as this weekend is about advancing a progressive vision for the Constitution, I imagine I don't speak too far by saying it's about networking for students in these trying economic times. In these trying economic times, I've been encouraged again and again and again to carefully manage my online profile, my online existence, and how important that is to make sure that I don't lose out on job opportunities and those sorts of things. I have good news. I have no sins to confess today. But I'm wondering if anyone...
It's early.
Yeah. Before noon. I'm wondering if anyone, and perhaps most pointedly Mr. Sparapani or Mr. Milch, can offer some practical tips about how I can, in fact, manage my online presence and avoid losing out on job opportunities, avoid spurious and coercive copyright claims, still remain a customer of your services, subject to ever-shifting privacy policies, and also find time to study and then sleep and then eat.
You should go ahead, because I have no recipe for such a
Sure.
complicated problem. The only thing that's good is you're very young and you can handle all those competing claims at
Yeah.
once. You're full of vim and vigor.
I have come to the opinion, after being in this field for a while now, that we are all entering an era where we have to recognize the failure of government to protect our privacy, both with respect to the government's relationship to us. We were talking about the ECPA debate earlier, and the respect to which companies are able to, unfortunately, target us in ways that we would not expect. And my answer is that, at least in part, we are going to have to accept as a culture and as a society that we have an individual responsibility, which is a part of ensuring our privacy into the future, which is to say, the people who recommended to you that you curate your online reputation are telling you something that is, I think, really good advice. I wish there was a Band-Aid that we could put over this, but Paul's point about the computational power of companies in particular right now is absolutely well taken. The inferences that we can draw and that other companies can draw about you are staggering. And where I think we have a failure, which we haven't talked about yet, is to take, well, in part we have talked about that. We need to take certain misuses of data off the table. You shouldn't be able to go to a business and have to pay more for the same good or service based on information you did not share with that company. If a third-party company is giving information to that business, I think as a consumer that seems inappropriate. You shouldn't lose a job opportunity. I think Gina is a great example, Mark, that you bring up, and we should model more of our federal laws after that. But let's be real here for a minute. If we tripled the size of the FTC and every state AG and gave every private plaintiff the right to sue any company out there, we would still not find adequate protection for exactly the kind of harms that you're worried about. And so that leaves me with this gnawing feeling that, again, we all have to take some responsibility to curate the information about us to the extent we're able to. Here's the piece of good news to end on. We are entering an era which I think is unprecedented. Not only do we have computational power, which is staggering, we also are beginning to compete as companies over the notion of giving you privacy tools to give you control over data. And that is a very new thing in the history of privacy regulation. So there is some good news to the end, but personal responsibility, I hate to say, will have to be part of this, I predict, for the foreseeable future.
Paul wants to follow up, but Tim, I just have to ask one follow-up. Wouldn't a big solution to the problem the young man has identified be disappearing data? Facebook could, if it chose tomorrow, say, before I post the drunken picture from Cancun, I want it to last for 3 days or 3 hours rather than forever. And there are apps like Tiger Text, named before the Tiger Woods scandal, that make this possible. I gather Facebook is actually looking into some of these technologies. Wouldn't it be a good thing if you guys architected this into the system so we could all have disappearing data and specify how long we wanted it to last?
On my notes here before the panel, getting ready, I wrote down data theft as a problem. I just talked about data harm or misuse of data as a problem. Third-party misuse of data purposefully given to one entity. And what I'm seeing is not just data breaches that are of concern, but actual theft taking place by companies who go and harvest data from legitimate companies which have a legitimate existing business relationship with consumers, right? If you look at the last 2 or 3 moments that Facebook has had great public scrutiny, it has typically either been that because Facebook or an app built on the Facebook platform had data harvested from it in violation of either our policies or that app's policies, and then that data was sold to another entity that has become the problem. So I think of this as a theft problem, a property right that's been abridged. And until we get serious about that, until the law prosecutes that, until we regulate that, I think we have real risks. And we're back in the spin cycle again. So we can create an eraser button, but if we don't erase it instantly, and somebody has stolen it because there's a new vulnerability that no one knew about before, which happens all the time, that's no protection in my mind.
Can I guess one thing here? I just want to, I'm sorry, Paul, I just want to suggest, and maybe it's harkening back to my earlier comment, but I think we haven't given society a chance to react to the new level of, or the absence of privacy, in the sense that we've got much of the burden of dealing with these issues has been in 2 camps. They're the people who are much younger who are dealing with it every day, and then there are the people who are much older who are allegedly in positions of authority who are trying to project their essentially embedded old views of privacy backwards or forwards on this gentleman's problem. My own view is that it's about a generation away from actually figuring out for society to adjust itself on how we're going to deal with these issues. I think that it's all well and good to have us, from our positions allegedly of authority, talk about rights of action, increasing government scrutiny, regulation, and the like, because those are actually the old tools of dealing with these issues. We haven't allowed a generation to come up and sort of say, hey, listen, when I have kids, this gentleman, when he has kids, he's going to tell them, now let me tell you, we used to say, this are the stupid things I did, and now he'll be able to say, these are the stupid things I did, don't do them. So I think I actually am a little bit hopeful that if we give this a little bit of time, society is going to actually deal with it. And sooner or later, it's not going to be a big deal when the president, when he or she has Facebook pages that they're embarrassed about, because everyone's going to have Facebook pages that they're embarrassed about. So it's just not going to be a big deal. So I think that, and then the generation after that will probably swing back horribly the other direction, and everyone will be really uptight and Puritans. But society changes and deals with these changes in technology. We've had lots of technological changes that have affected society greatly.
Anthony Weiner,
I
a
know,
man before his time.
Right.
He's a man of his time.
So really quickly, what I want to say, and I agree with some of what was said, not all of what was said. I don't worry about you, because you're already cognizant about the problem and you're going to watch what you do. I worry about my 6-year-old twins And as far as I'm concerned, they won't know Facebook exists, and I can impose the filters in home to make sure they don't know it exists for as long as I can stretch that out. But a lot of what I want to say is said, but it's a little bit about individual responsibility. It's a little bit about corporate responsibility too. They need to give us the handles upon the levers that we can pull in order to get the kind of privacy we want. For those of you in the room who have ever said, kids today, they don't want privacy, if you've ever said that, go read the work of Dana Boyd, who spends her entire career interviewing teenagers around the country about their Facebook use. And she asks them to use Facebook while she watches. What she has concluded, she's now focused like a laser on privacy. She's concluded that they desperately want privacy. Their definition of privacy is a little bit different than ours, but they feel cheated that the adults in their lives are not giving them the tools they need to get the privacy they want. So they're inventing things. She has wonderful stories about how you'll post something that your mom will think means X, but your good friends will really know means Y. Right? That's a sad state of affairs. Why aren't the companies helping these kids more get the level of privacy that they want?
Kids have been lying to their parents for forever. I hate to tell you. I know your kids are only 6, but
they've never lied to me once.
Jeff,
yeah.
Can I work? Can I work in a Brandeis reference?
I was hoping you would.
Thank you.
Is there any other?
Well, Jeff and I have a long-running joke that all privacy roads lead to Brandeis, but it's actually a little disappointing. We're near the end of the session, and there's been no Brandeis reference.
We did twice.
I mean, what does that say about discourse? But anyway, so I just want to, I love paradox and privacy, and I think so many things turn out to be counterintuitive but true. And here's a fascinating thing about our modern right to privacy, the right to privacy described by Brandeis and Warren and the one picked up in the early part of the 20th century. It had to do with the question of what happens when a person's image in a public space is obtained and used by others without their consent, right? That it's written about in news stories, that it's used for advertising purposes. It wasn't about the privacy, the secrecy, the locked doors that we sort of think about as private, which in fact is a privacy that we obtain through technical means. It's what happens when the technology doesn't provide the safeguards and now the law needs to intervene. And the law intervenes because people's data and image is now out in a public space and accessible to others. And we have to start asking some questions, even though as a physical matter, as a factual matter, yes, the image is available to others, but that only begins the legal discussion. And I think about this, in the context of Facebook and Google and all these other discussions we're having. That's actually the starting point for the right of privacy. And I am just hoping that someone will actually write a book about Brandeis and help us understand how these original insights can give us a better perspective on some of the challenges we're facing today. So back to you, Jeff.
Gee, Mark, that's a great idea. I think I'm going to get to work on it right away.
Let me chime in. I have one priceless tip on how to protect your privacy going forward. Do not give your child an unusual, unique name. There is only one of me, and this can be very inconvenient.
Wonderful. Now, Brandeis was also very big on timekeeping and scientific management, and we are out of time. I'm supposed to remind you to join us for the closing plenary, free speech, and the Roberts Court, the First Amendment in the first 5 years. Please join me in thanking our excellent panelists.